The Honorable, the Supreme Court.
Good afternoon. Thank you all very much. Please be seated, and when you're ready, please call the case.
Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled State of Vermont v. Kent Eaton, case number 24 AP 121. Representing the appellant, Kent Eaton, is attorney Rebecca Turner. Representing the appellee, the state of Vermont, is attorney Andrew Gilbertson.
Okay, counsel. Please, for the record, introduce yourself, identify your client, and then proceed.
Thank you, Your Honors. Good afternoon, Rebecca Turner for appellant, Mr. Kent Eaton. We are here today to appeal the trial court's denial of his motion to suppress evidence in connection to a warrantless search for his breath subsequent to his arrest. Is this mic a little too close?
Yeah.
Is that better?
Yeah, that's better.
Thanks. And so the appeal here, the motion below raised three grounds for granting the motion to suppress. One was that it was unlawful, that the consent wasn't valid. It was both involuntary and not knowingly made, and the state, though noticed, declined to respond, declined to meet its burden. The motion was reserved. There was a hearing. Evidence was presented only by Mr. Eaton. The state declined to call its own witnesses. And then the trial court ruled. And the trial court should have, at that point, granted the motion because the state sat back, declined to show that the consent that was given, that was challenged, that was noticed, that was in fact lawful.
So Ms. Turner, let's get to the trial court's decision based heavily on Burdett and stating that if it wasn't suppressed, and if they were going to reverse in the suppression and Burdett, you got to say that it's a valid test. So what do you say about Burdett? How do we distinguish Burdett? How do we get around Burdett? And what should we do with Burdett? Three questions, so you can answer them one at a time.
And I'll try to recall them all. First, what to do about Burdett? The trial court just erroneously misapplied that decision. But before that error is explored, the court should never have even tried to make the state's case for it, which it did here. Violating fundamental party principles, party presentation principles, separation of powers, concerns underpinning that very principle. So the court should never have, in the first instance, raised it to counter the arguments raised.
So is that the point that it was the court that first raised Burdett? Is that your point?
The state only responded to one of the three issues raised by Mr. Eaton. The court used and relied on State v. Burdett, which the state did cite to the question of whether he had a right to counsel, which that decision is limited to, not addressing the issue of whether the consent was voluntary or whether the consent was knowingly made. So the state raised it only for that, only addressed that one of three issues. The court picked that decision and used it to dismiss the unaddressed challenge of that it was not knowingly made. So that was error number one. It was the state's burden. It wasn't Mr. Eaton's at all. The court erred in dismissing the other issue with that it was involuntarily made because Mr. Eaton did not cite authority supporting the assertion. Again, it wasn't Mr. Eaton's burden to prove at that point. Had the state attempted to make its burden that the consent was in fact lawful.
So Ms. Turner, when I was analyzing the case, I was trying to determine if there was a statewide standard of care for a DUI consult. First offense, second offense, third offense, accident, no accident. Would there be any consistency or would it be on a case-by-case basis depending on so many variables that could never have a state standard?
This court's precedent in analyzing similar challenges in the past, whether it's the statutory right to counsel, the statutory right to make an informed decision, motions to suppress under Article 11 or Fourth Amendment, that's all, of course, individual facts presented. But here, we don't have anything that was argued by the state, voluntariness of the consent, for instance. is an individualized totality of the circumstances standard of review. But we don't on this record know what the state would have argued or what we would have responded in kind. What we have shown was that it wasn't a frivolous argument in our reply. We cite to decisions where similar misrepresentations by a state actor to obtain under false threat of prosecution or commitment of another crime, that has rendered invalidated consent. So it wasn't a frivolous claim, but even so, it wasn't Mr. Eaton's burden to prove in the first instance. And that was the error that the trial court did. And so on that level, this should just be reversed and dismissed. This court has never upheld a challenge where the state actor, the police officer, law enforcement, misrepresented a material fact to a motorist being subjected to these warrantless breath tests at the police station. Has never upheld a challenge by the defendant where the state actor, the police officer, provided misinformation, where also the attorney, the on-call attorney, didn't correct the information, and also where the defendant himself or herself had the actual accurate information, just held it back. We have everything here. We have, although unintended, misrepresentation of the fact that he had a prior DUI. Mr. Eaton, in fact, did not have a prior DUI conviction, but this was related to defense counsel. And so defense counsel relied on this. The court found that Mr. Eaton relied on the advice and that the defense attorney relied on this misadvice or incorrect representation by the officer to then advise that you should take this test because you will, if you refuse, be subject to the additional crime of refusal.
Does
Can I
your
ask a
argument, I'm sorry.
Go ahead. All right, I'll go. In terms of knowing waiver and voluntary waiver, are you suggesting that those are constitutional issues here, or do they arise under 1202?
The knowing waiver is derived from 1202. And so that is a point of attempted clarification in the reply where the state appears to have misconstrued our argument, our issue number 2 unknowingly. That issue is consistent with what this court recently addressed in State Viatori. The
Excuse me,
State Viatori,
Thank you.
where there was recognition by this court that the legislature established through the implied consent statutory scheme, otherwise known as implied consent rights.
But isn't Tory Attorney Turner, isn't a Tory distinguishable? Because in a Tory, it was the implied consent procedure, and the procedure directed that the law enforcement officer had to give the results of the first test before telling the defendant, you can take a second test. So that's statutory procedure. Is that different from this where although it's in the statute, it says a meaningful opportunity to consult? And wasn't the defendant given a meaningful opportunity to consult? I mean, he had every opportunity to talk to an attorney, which he did. I mean, he certainly seemed to understand what his rights were when he was stopped and immediately said, I invoked the Fifth, I'm not talking, wouldn't talk. And then when he had the discussion with his attorney, he suddenly became very confused and wasn't sure whether or not he had been previously convicted of a DUI.
So it is not, State Viatori addressed a different procedural right under the statutory scheme, but it is on point in terms of establishing the analysis and recognizing that the scheme itself, the implied consent scheme, set forth implied consent rights, that a person has the right to make an informed decision before submitting to the test. Here, the issue is that he was never properly informed as to the applicable consequences should he refuse here. It wasn't that he was generally apprised. We're not arguing that that any defendant being read these rights could face this, could argue this challenge, make this challenge. It's here, it was the material misrepresentation of the officer. Not, and if I may, it was that misrepresentation as to the consequences as they applied in this case that was what was misinforming, what rendered his consent unknowing, consistent with state viatory. So this isn't a challenge as to his separate right to a meaningful opportunity to consult with counsel. That's a separate issue and untethered from a Tory in the sense of what rendered it unknowing. Here, the officer failed to properly apprise Mr. Eaton about the applicable consequences of not taking the test, given his priors. Had he been told correctly that he did not have a prior conviction, this issue would not be before the court. But here we have an officer misrepresenting the fact that he did, changing the consequences completely. He thought on false threat that he was going to be subject to a separate charge. His defense attorney.
The opportunity and the right to consult with counsel, not the right to get information from a police officer or correct information from a police officer.
The right to make a knowing decision, as it played out with the facts in this case, meant that Mr. Eaton never got the information, the correct information.
Is there a duty on the defense counsel to have made further inquiries when she testified that she had no recollection of the conversation, but Mr. Eaton testified that he was kind of fuzzy, said that wasn't quite sure when the defense counsel asked him these questions. Is there a responsibility on the defense counsel to have at least sussed that out, to make a determination as to whether or not that information from the law enforcement officer was accurate?
Not on this record, Your Honor. The trial court found clearly, and these facts are undisputed. There are no facts in dispute. She gives general advice based on what she's told. She was told that he had a prior DUI, and therefore she told him and advised him that he should submit to this test given his prior conviction. And because the trial court also found that Mr. Eaton relied on this information, that he didn't otherwise independently know that he did not in fact have a DUI conviction, and because the officer never told him otherwise, Mr. Eaton was left in this instance with misinformation. And based on this misinformation, this false information that he was at risk of threat of a further prosecution, he submitted. That rendered his consent involuntary, not knowing, and certainly denied him a meaningful opportunity to consult with an attorney. Three separate issues. And it is, any one of them would have warranted reversing.
Can we address your third issue, the meaningful opportunity to consult without overturning Fredette?
Yes, Your Honor. Fredette's distinguishable. And that was because ultimately the Supreme Court found in Fredette that the defendant had the accurate information and had the clarity of mind at the time of the consult to have shared that information. And so that when the on-call attorney told him incorrectly that he didn't have the number of convictions that he thought, he thought, this court found that the defendant could have shared that information. And so the
knowledge in Fredette, he had knowledge of the events in this, it was quote fuzzy, close quote.
Yes, but not just fuzzy. It was that he didn't have the information, and this was what was he was not of clear mind. So the fuzziness makes it distinguishable from Fredette, where the defendant there had clear mind, so that he could have recalled his. Here, the testimony of Mr. Eaton, found to be credible by the state, was that he actually wasn't sure. And in fact, what we know was that he was charged with DUI, but the conviction was downgraded to negligent operation. And so in any event, that is how we don't, this court doesn't have to overturn Fredette. It just merely needs to look at how narrowly it applied to just that issue of meaningful opportunity to consult with counsel and also see what happened there. Ultimately, Mr. Fredette could have shared with defense counsel accurate information that would have given him an meaningful consult. Here, Mr. Eaton didn't have access to that correct information, neither did defense attorney, and the state provided that misrepresentation. How can the state profit from representing incorrect information? At what point is the state going to be allowed to search someone's breath without a warrant, provide misinformation to the defendant so that they can't make a knowing decision to submit where they've actually provided the incorrect information? Thank you, Your Honor.
Okay, thank you. We'll hear from counsel for the appellee, please. Come on up, introduce yourself for the record and your client, and then proceed.
Good afternoon, Your Honors. My name is Andrew Gilbertson, and I represent the state of Vermont. Just to address the point about Ettore, I'm sorry, am I pronouncing that correct? Ettore? Is that case specifically involved information that the statute guaranteed a operator prior to taking the test. The statute says that they are entitled to hear the results of the first test before they decide to take the second test. There's nothing in the statute, implied or explicit, guaranteeing an operator to their criminal record or to their DRI
But
record.
aren't they entitled to a meaningful consultation with an attorney?
They are, and Ettore and Fredette both indicate that having an opportunity to speak with a lawyer gives them.
Opportunity is different than a meaningful opportunity. A meaningful opportunity means that they can have a private conversation, a private consultation, and that they have important information that's in front of them. I mean, the opportunity to consult is different than a meaningful one. Don't you agree?
Well, I would say Eaton addresses that, and Eaton, the court, in that case, the on-call public defender was contacted, but effectively there was no conversation that was had. And in that case, this court found that the 1202C obligation for a meaningful opportunity to consult with an attorney was satisfied. And so if that is enough to satisfy 1202C, then there should be no obligation that they have all the facts before them about the specific case.
Is there anywhere that you find a defense counsel has the right to rely on law enforcement's representation about her own client, absent bad faith, that there should be a remedy?
I don't think that there is a right for an attorney to do that. I think that a defense attorney in that situation could very well say, well, the police are reporting this, and they can decide whether or not that's accurate, whether or not they believe the police officer. If they get contrary information from their client, then they can assess that. They can assess, well, you're telling me you don't have a DUI. The record says you do have a DUI. And this is what I can tell you about the consequences in either scenario. And then the operator will have to make their decision.
Isn't it really a question of the officer doesn't have to tell them if the attorney asks, right? You've said.
That's correct.
Right.
That's correct. In
So-
Ironside,
If the officer says, no, I don't have to tell you whether they have a prior record, your position is that's perfectly legitimate.
that is perfectly legitimate, and that is what's stated in Ironsides.
But on the other hand, if the officer is going to say something, isn't there a fundamental right to have it be accurate as opposed to having the parties have to, the defendant look at counsel and go, what do you think? You think he was accurate or not?
Well, that would would guarantee the accuracy of the information from the police officer. And I did not see that in my research for the case where the court has found that the state has an obligation to provide accurate information, particularly in this scenario.
But Ms. Kruska testified that she needed accurate information to give meaningful advice to Mr. Eaton.
Well, I think the meaningful advice would likely be what are the consequences are in either scenario. Mr. Eaton was fuzzy about whether or not he had a DUI in the past. She could have told him that that his fuzziness, well, the police officer's telling me one thing, you're fuzzy on what happened. This is the consequences of either decision depending on whether or not you believe the police officer.
Doesn't it change things though when the police officer attempts to provide the information? I mean, he or she could keep their mouth shut, say, I can't tell you, but when they undertake to say, this is the state of affairs, don't they have to be accurate? And if they aren't, isn't it on them? Because there's no real way for a defense counsel to run a record check in the middle of the night. They have to rely on what the cop tells them.
It was actually, it was interesting in researching this, the case Velez from the early 2000s, this court recommended that the court provide access to public defenders so they can research that in night. When the state embarks to provide information, when a police officer embarks to provide information, I would argue that there's nothing in the law to require that. And as of right now with Fredette, there's no guarantee of what the police officer is saying is accurate. It would constitute a violation of the statute. If there are no more questions, the state will rest on its brief.
Okay,
Thank you very much.
very much. How much time does the appellant have, please?
Appellant has 6 seconds remaining.
Well,
Thank you, Your Honor. The state's proposal is unworkable. In 30 minutes, the defense attorney is supposed to ask for a record check. Thank you, Your Honors.
thank you. Please call a conclusion of the hearing.
That concludes today's hearings.